Good afternoon, everyone, and thank you so much for joining us today. Thank you for your patience as we waited for the rest of our group to log in. We are very, very pleased today to be able to bring you this update. Republicans taking the Senate, what does it mean for Obamacare? We've also got a recent FAQ as of yesterday from the HHS, IRS, and DOL in collaboration, so we'll get a little flavor on that. And we'll also be able to bring you an update as of 3 minutes ago on the decision from the Supreme Court as it relates to subsidies. So I'm very excited. My name again is Jenny Dodson, and I am the Associate Director for the Healthcare Reform Center and Policy Institute. I have the privilege today to be joined by two great people, Ronell Nolan with Health Agents for America, HOPA Fights for Agents, and I'm excited to be able to have her join us and help us moderate this, as well as, of course, Ben Conley, Seyfarth Shaw. He's an attorney in employee benefits and executive compensation. He's also part of our faculty for the Healthcare Reform Center and Policy Institute. So we're here for you to bring you updates, help you prepare, and help you have the most up-to-date information at all times. You will be able to ask questions in the Q&A module here on our WebEx Event Center. And as you do, we'll moderate those questions, try to get to as many as we can. So I will not take any more time. I'm going to turn this over to Ronell Nolan, who has, again, helped us and joined us, and we are so glad to have you, Ronell. So Ronell Nolan, President, CEO, Health Agents for America.
Hi, how are you? Thank you so much, Jenny, for allowing me to be a part of this very exciting webinar and very timely webinar. Health Agents for America is a non-profit trade association fighting exclusively for agents. So these are one of the things that we do is make sure that agents know in real time what's happening, which that means immediately. And excited to have on the call also is Mr. Ben Conley, who I understand has some very exciting news. I think you said a couple of minutes ago while I was driving, so I'm excited to hear what he has to say also. Benjamin?
How are we looking now? Can you hear me?
Perfectly. Thank you, Ben.
All right, thanks. I was just talking about how exciting of a week it has been for an employee benefits lawyer. Not that every week for an employee benefits lawyer is not exciting, but there's been a lot going on. So, you know, I think that when we started planning for this session, we said, well, wow, can we really talk for 30 minutes about election updates? And now, in light of the more recent developments, we got a lot of material to cover. So I'm going to jump right in. I'm going to start with some political developments and then move on to some legal sort of technical developments, but significant ones for that matter, especially, I'm sure, for a lot of people on the phone. So most breaking news, start with this, so hopefully you hear first. The Supreme Court has just agreed to hear the challenges to the Affordable Care Act marketplace subsidies for federally facilitated exchanges and federal-based exchanges. Now, just for background, as everyone knows, every state has a health insurance marketplace. The question is just whether that has been established by the state directly or by the federal government or in partnership with the federal government. Due to a well, depending on your perspective, I guess, either a technical glitch or an intentional drafting provision in the law, the health insurance tax credits that are available on those marketplaces are purportedly only available to exchanges established directly by the state, which frankly is only, I think it's only about 14 of them out of the 50. The vast majority of exchanges have some federal involvement. And so the IRS saw that, and when they wrote initial regulations, they said, of course, that wasn't the intent. Subsidies are available on all the exchanges, meaning everybody who goes to the exchanges can get some form of subsidized health insurance coverage, subject to, obviously, employer-based coverage or income levels. So there, in the interim, there have been a few court challenges, and courts have split on this, and the D.C. Circuit, for instance, went one way and then got pulled back in an en banc decision. It looked like this matter was headed to the Supreme Court all along, and as of, I guess, 12:55 Eastern today, the Supreme Court agreed to hear the case, which means that we're going to have a decision one way or another, and it'll be really interesting to see what happens. Now, I mean, this challenge has probably the most significant chance of really derailing the law. I mean, more than anything we're going to talk about in a moment relating to the election, if there are no subsidies available on the federal-based exchanges, here's what that means. Number one, individuals are far less likely to enroll for coverage on those exchanges because it becomes far more expensive. I mean, you're talking about significant federal subsidies, and you could be looking at thousands of tens of thousands of dollars of additional costs for individuals enrolling through those exchanges. Number two, we got to see how this is going to play out, but that's going to have a significant impact on the employer mandate, specifically for employers that exclusively have operations in the states that have a federal exchange. And the reason why is that the employer mandate penalties are only triggered to the event that an individual goes to the exchanges and gets a tax credit. So obviously there's still 14 states that are going to have tax credits, maybe more depending on the outcome of the ruling if states inadvertently rendered themselves ineligible. But what that means is that employers that are sitting in those states and don't really have significant operations elsewhere, they might be able to effectively ignore the employer mandate because there's no way that a penalty will ever be triggered for them. So big implications. Needless to say, I don't need to discuss the breakdown of the court because everybody's seen that. 5 conservative justices, 4 traditionally liberal justices. And despite that leaning, they don't always come down on the same side of things. So notably, Chief Justice John Roberts sort of saved the law when there was a challenge to the individual mandate back in 2012. Justice Kennedy is historically a swing vote, so it's really hard to say for certain how the court might rule in this regard. And it is sort of an ambiguous matter. I mean, you can make strong arguments on each side as to whether the Congress intended this result or whether it was truly just a typo. So stay tuned. In terms of timing, I'm guessing what we'll see is that we'll hear oral arguments at some point early next year, likely in March. That usually gives a pretty good indication as to which the way the court is leaning, although the oral arguments following the 2012 challenge suggested that the law was absolutely going to be struck down. Maybe I'm overstating that, but strong indication. And then, allegedly there were some backroom dealings that saved the law at the end of the day. But we'll likely hear something probably around late June. If I had to place my money, I would say June 28th, 2015. So stay tuned. Again, that's a big one. That's a big challenge. And more than anything else, that has the potential to have the most significant impact on the overall fundamental structure of the law. Shifting gears, I do want to talk about the election because that was what was promised here. And I think the key takeaway here is that, at least for the time being, don't expect any significant changes or overhauls. Here's what played out, obviously. Prior to Tuesday, and even now until the new Congress is sworn in, you've got a Democrat in the presidency, obviously the president who takes responsibility for and ownership of this law. The House of Representatives has been dominated by Republicans for years now, and the Senate has held a slight Democratic majority for the last, I guess, probably about 4 years now. And as a result, what you saw was that there were a lot of initiatives generating from the House of Representatives that would then get passed over to the Senate, and they would die because even if you only have a slight majority, if you do have a majority, you sort of control what gets pushed forward. So now we have a flip, right? So we have all of Congress being held by the Republicans, and the Senate is now looking at a slight Republican majority. Where that stands, where that ends up is going to be anywhere between 52 and 54 seats held by the Republicans. What you don't have there is a supermajority like what you had back in 2010 when the Affordable Care Act was pushed through. So that means a couple of things. One is it means that the Republicans don't have a clear path to just automatically push through anything they want. There are still the 60-vote filibuster rules, and even if you pull over the moderate Democrats in Congress, of which there are far fewer now, or the moderate Democrats in the Senate, you still don't hit that 60-vote threshold. Even so, there have been some changes to the filibuster rules over the last couple of years, and the Republicans have indicated that similar to the way that the Affordable Care Act was passed, they are looking at using the budget reconciliation process, which requires less than 60 votes, and that might allow them to be able to move some initiatives through. We'll see where that ends up, but the thinking is that the Republicans should be able to pass some measures and get those measures out of Congress and over to the President's desk. Now, obviously, the President has the veto authority, right? So while the veto can technically be overcome by a supermajority in Congress, that simply doesn't exist and probably won't exist on most things. So what you're going to be looking at is, number one, which bills are going to make it to the President, and number two, which bills the President would be willing to sign, or rather, which bills the President wouldn't attempt to veto. So there's already been announcements. So the Republicans are going to once again push a repeal of the Affordable Care Act, a full-scale repeal for the 65th time, I believe, is what it would be now. Obama has already said he's going to veto that. Another thing the Republicans have said they're going to propose is a repeal of the individual mandate. Once again, the President has already come out on record and said, I'm going to veto that. The reason being, obviously, if you have no individual mandate, you can't really have a pre-existing condition exclusion. So while nobody likes the individual mandate, everybody does, presumably like the pre-existing condition, the ban on pre-existing condition exclusions. Repealing the individual mandate would sort of effectively serve as cutting the legs out from under the law. So those measures will probably both make it to the President's desk, but both will probably be vetoed. And that latter is particularly difficult because then it would force a number of Democrats to go on record voting in favor of the individual mandate, not a popular provision, but you can kind of see the logic as to why those elements are going to be pushed through. That being said, I read some stories that suggested that the President is secretly a bit excited about the change in the makeup of Congress, and here's the reason why. When the Republicans were the minority in Congress, or at least not fully in control of Congress, when things weren't happening, they could blame the party in control, that being the Democrats. Now that the Republicans are in control, they bear all the risk of being labeled in the role of having a do-nothing Congress. So from the President's perspective, what I understand is that he's optimistic that this might lead to what allegedly used to happen in Congress, which is negotiations and a little bit of give and take, resulting in some things actually happening. So there are some provisions in the law that are uniformly unpopular and have broad-scale Democratic support for repeal as well, and those include, for instance, the medical device manufacturer tax. There are a lot of medical device manufacturers sitting in states with Democratic representatives and those representatives have been pretty vocal that they want to get rid of those laws. So that might be one aspect where you see a change. Another area that I've seen indications that that Congress might try to work on are, maybe perhaps tweaking to the definition of full-time employee under the employer mandate. That could be big. That could be pretty significant depending on what they do. But there's pretty significant Democratic opposition to moving that standard from 30 hours a week to 40 hours a week. So I don't think that would be passed uniformly, but what you might see is some sort of compromise along the way, whether that means 32 hours a week, 35 hours a week, a change to the process for determining who is a full-time employee, which the folks on the phone know is one of the most complicated things to figure out that really exists out there. So I guess the message is stay tuned. Putting aside the Supreme Court decision, I think what we're expecting is that we're going to see some tweaks around the margins, but nothing changing to the core nature of the law. And notably, the employer mandate is, as soon as I say this, it won't happen, but probably almost certainly going to go into effect in 1/1/2015, which is, a month and a half away. So I think that, what we're telling our clients and what we're advising is proceed according to the assumption that that's going to be in effect. So don't risk that one, and don't try to be proactive, be reactive in terms of changes there. All right. Those are the two big elements. The third element I wanted to discuss is the timely activity by the IRS and other federal agencies, which I think is no coincidence, just happened to align with the election day and the days following the election, on closing a series of loopholes that were seen as workarounds to the employer mandate. So let me just talk about what I think are probably three of the most popular that were shut down either on a prospective basis or immediately at some point this week, many of which were yesterday. So the first strategy that we saw a lot of people adopting was taking advantage of a glitch on the IRS's minimum value calculator that allowed you to provide minimum value coverage without including hospitalization in your plan. Once again, in order to avoid penalty entirely under the employer mandate, you're required to offer coverage that provides minimum value, which is generally viewed as a 60% actuarial value. The IRS calculator, due to some sort of actuarial errors, allowed you to get there without hospitalization. It appeared that this was technically legal, but the IRS knew about it and was indicating they were going to shut this down. And they did as of Tuesday morning, the election day, but only on a prospective basis. And what I mean by that is if you inked a deal on a minimum value plan prior to Tuesday, you get a 1-year grace period before you have to get rid of that plan. So if you structured in a minimum value plan, you started open enrollment, really just if you inked the document setting that plan up, you get a free pass for all of 2015. On the other hand, if you did not get that set up, you don't get that free pass. But what the IRS has said is, look, this isn't like we're interpreting the rules. The rules were wrong, and we're going to go fix the rules. So what that means is that until they issue final regulations, as they say, minimum value plans, from what we can tell, still work, even if they don't have hospitalization. So that probably gets you a couple months. And now, I don't know that it's worth entering into an arrangement to offer a minimum value plan for January, February, March. It looks like those are going to go away in March. But, you know, perhaps it was a threat, and it'll actually be pushed farther down the road. Obviously, Congress has changed, so they can do some things to turn the screws on the IRS. You know, it remains to be seen. But the long and short is, if you had a minimum value plan in place prior to November 4th, you can keep it for a year. After that date, proceed with caution. Two other arrangements I want to discuss. One is this creative strategy that was employed that was built on the premise that there's no prohibition on incentivizing your employees to go to the exchanges and get a tax credit. You can be penalized for discouraging them from doing so, but there's no prohibition on incentivizing them. So what a lot of people were looking at doing was offering their health plan, telling everyone they were eligible, or, you know, all full-time employees they were eligible, but then identifying high-cost claimants and saying to those individuals, look, you can stay on our health plan, have at it, continue incurring millions of dollars of claims per year, or we'll give you a $10,000 bonus if you agree to leave our health plan and you can go get coverage on the exchanges because there's no pre-existing condition exclusion. Obviously, there are some moral conundrums surrounding that approach, right? Because you're moving that individual to the government's dole, but it didn't appear that there was anything illegal with it. The DOL came out, and the relevant regulatory agencies came out yesterday afternoon and said, actually, we think this is illegal. And the reason why, it's a bit of tortured logic, but what they're essentially saying is that we prohibit discrimination based on health status. Now, you might say, well, this isn't discrimination against somebody based on health status. This is discrimination in favor of somebody based on health status. You're giving a better deal to people who are sick than the people who are healthy. But what the DOL said is, well, what you're saying is we charge our employees $2,000 for health insurance coverage. We're going to offer our sick people $10,000 to decline our health insurance coverage. What that essentially means is that for those sick individuals to take our coverage, rather than paying $2,000, they're paying $12,000 for that coverage because they're foregoing that $10,000 bonus we offered them in order to get our health insurance coverage. Kind of tortured logic to get there. It is what we would have considered benign discrimination because it discriminates in favor of people who are sick, but the DOL came out and said, we disagree. We think that's prohibited under HIPAA, and you can't do it. They had some other concerns with it as well, which I think largely could be worked around. Notably, they said, hey, if you're doing this under your cafeteria plan, which you would have to be doing because it would be cash in lieu of health coverage, you run the risk that you're discriminating based on income. But again, that assumes that the individuals who are the sickest individuals on your plan are also the wealthiest individuals in your organization, or the ones making the most. So again, sort of empty threats, and we think it's a bit of tortured logic, but the DOL has put its stake in the ground in terms of how it approaches that type of coverage. The other two, which I'm going to only touch on briefly, were arrangements whereby people were saying, all right, we're not going to give you pre-tax coverage for individual insurance policies because that's been prohibited, but we'll do it on a post-tax basis. The DOL has said, if you're reimbursing health coverage premiums or out-of-pocket expenses on a post-tax basis, we view that to be a health plan in and of itself, which means, number one, the employees are ineligible for a tax credit on the exchanges, and number two, you're potentially in violation of the preventive service mandate and the annual dollar limit rules, so we don't think that practice works. So query whether there are ways around that. Again, if you, well, you know, I don't want to get into nuances there, but what you've seen this week, I guess I would say, is the IRS and DOL shutting down a variety of loopholes, creative strategies, some of which were a stretch, but others of which seem pretty plausible, in order to sort of leave the original landscape that was envisioned, which is that employers have the choice of either offering coverage or paying a penalty, and there's not really any in between. So with that, I'm going to pause, and I think, I don't know if we have capability to do this, but maybe either take some questions.
Yeah, absolutely. I'd like to just add a couple of things before we take some questions, is the fact that I totally agree with a lot of things that Ben said. Absolutely, the American people have spoken. The Republicans now have the House and Senate, but we do have a Democratic president who has veto pen. So absolutely, there'll be a repeal called for. There'll be a vote because that's what they promised the American people, but you will not see anything happen on that front. You will see some things. They'll try to fix some things going forward. But the important thing is the open enrollment starts November 15th. The new Republicans will not be in their seats by that time. You have the individual mandate, so you have very many things that are happening right now. So we, as agents and employers, need to work in the box that we've been given, which means that we have to adhere to the ACA laws as they are now. As they go forward and they morph and they change, then I'm sure we'll make sure that you know about those things. But you're going to see some changes as usual because there have been changes in the past. You'll continue to see more changes. You'll see more Republicans move together and work together where the Democrats and Republicans in the last several years have not come together and worked on a lot of things. And I agree with Ben about the full-time. You might see some changes with that. There's a lot of employers, a lot of talk on Capitol Hill about changing from 30 to 40 or moving a little closer. So there are a lot of things that are going to be happening going forward. So it's an exciting time for the American people. And Ben, you might, not sure if you can see the questions.
I can, yeah. I'm happy to take a couple of these. So a few. So one of the questions is there are some TPAs administering an employer-sponsored tax-free contributions to individual policies with legal documentation to support the program. What's your take on this, please? You know, I mean, I think while some of the loopholes we seem to think were legitimate, this was one that we never really understood why this worked. So I've never seen the legal documentation. I know I saw a website yesterday that purported to have a book that they were about to publish on why this worked. But the bad news is the IRS confirmed specifically that arrangement does not work. So proceed at your own risk, but know that if the IRS ever looks at that, they're going to shut it down because there is simply no, I mean, the IRS has made abundantly clear that you cannot provide tax-free reimbursement for individual insurance policies. Another couple questions here.
I'll take a question, if you don't mind, about the subsidies. I know you touched on it a little bit. Definitely something that we need to pay attention to, the fact that the original law says that you have to have a state exchange to get a subsidy. And again, as Ben said, the IRS came back, said that they felt like the intent of the law was they meant federal funded. I think that, as I said, you have to operate in the box that you were given, which means that subsidies now are eligible for those that live and have federally funded marketplaces in their state. So as far as if people are going to have an impact on their subsidies, if they're going to be asked for it back, there is a sliding scale for those that have, did not qualify their subsidy correctly. But I think from the calls that I've been on, CMS is going to be looking at those people between 300 and 400% of poverty. They're looking for those people that made a lot of money and got a subsidy to ask them to pay that back. But they're going to be sending the reporting forms to the employers. That's how they're going to find out about those individuals that might have gotten a subsidy and their plan was affordable and met minimum value to their employer.
Yeah, that's right. And then in terms of specifically whether the Supreme Court's decision will have any retroactive impact, we'll cross that bridge when we come to it, but I think the IRS's indication has been that there's not going to be any retroactive impact in that regard. Now, what Ronell was mentioning is a separate and distinct topic, which is what if you reported you have a lower income and you actually have a higher income? I think you're absolutely potentially at risk there. But in terms of if you legitimately qualified for that tax credit, will that go away retroactively? I don't think so. But, again, it's hard to say. Couple others here. Another question is, can you discuss whether it's okay to give an opt-out credit on an after-tax basis to employees who hand in waivers showing other coverage? I think that's still fine because what the IRS has said is we don't want you discriminating or identifying people based on health status. If you're simply using an opt-out credit that is uniformly available regardless of your health status, that does not run the same risks that are associated with just identifying people who are sick. And that's a very common employer practice and has been endorsed by the IRS in 125 rules. So I don't see any issue there as long as you're not using that as a subterfuge to avoid offering coverage to individuals who are high-cost claimants.
And there's a question about employer subsidy notices, and this one is very near and dear to my heart because, we worked so hard last year to get that out to the employers, and then the federal government came back and said that, you're not going to be penalized. I was in a meeting the other day where they said absolutely the Department of Labor is going to be using the fact that you did not send that out when they audit your employer plan, and you will be penalized if you do not send that out. So I have encouraged my agents to encourage their clients to go ahead and send those marketplace notices out. Let that employee know that their plan meets affordability and it meets minimum value so they know whether they're eligible for a subsidy or not. So the law says that you're not going to be penalized. It doesn't give you a direction that you have to do it, but I think that it's a good idea to do it, and that especially if you're audited by the Department of Labor and you're going to be penalized on the back end, you might as well get in compliance now.
Yeah, that's a good point. And then I think along those lines, there's also a question about subsidy notices from the exchanges, which is the exchange notifying you that one of your employees has received a subsidy and offering you the opportunity to contest that determination. And the way that process is going to work is you're essentially going to have two bites at the apple. One is when the exchanges notify you that an employee received a tax credit, and the second is down the road when the IRS notifies you of as much. The question is, do you have to respond to the first one or can you wait for the second one? Unfortunately, I don't think we've developed a best practice on this because I've been trying to get my hands on one of these notices, but I haven't been able to yet. But I guess what I would say is if you have the capability to respond and the resources to devote to responding to the HHS notice, that could save you some heartache on the back end. But you're absolutely going to have another opportunity to respond down the road with respect to the IRS notice. Jenny, let me know your thoughts. There was a question or a request for just comments on the Honeywell case, which isn't necessarily the core of this topic, but I know I want to be respectful of folks' time, and I know we're already over here.
Hi, Ben. Thank you. And thank you for the question on the EEOC and the Honeywell case. The Healthcare Reform Center and Policy Institute, in collaboration with the Corporate Health and Wellness Association, is in the process of putting together an update on that. So we are going to dedicate some time to that very soon, likely next week, so be on the lookout for that. Will either be an article or a webcast update, which will be a crossover for our CCWS students, our Certified Corporate Wellness students, and our Certified Healthcare Reform participants as well. So it's important information, and we're going to get some weight on that, and we'll do that in the next week, I hope. And,
okay.
and right, so in light of everybody's time, Ronell, Ben, and all of you, we have hit the exact 30-minute mark, and I'm sure you have lots of questions. Feel free to email me. It's jenny@employerhealthcarecongress.com or info@healthcarereformcertification.com. Either one comes to me. I'll be delighted to push your questions on to the faculty for the Healthcare Reform Center and Policy Institute, and specifically over to Ben with Seyfarth Shaw, and or to Ronell with HAPA. And any closing words that you both might have, I'd love to give you that opportunity. And thanks again, everyone, for joining us, and hopefully we can continue to bring you these updates.
Thanks, Jenny. The only thing I would say is stay tuned, because I think we've not seen the last of the flow of guidance that's coming prior to the swearing in of the new Congress.
And I would just like to say is what I always tell everybody is a good tagline is, what I tell you today is the truth, but it could be different tomorrow, but if it is, I'll let you know.
Awesome. Thank you, Ronell. All right. Thank you all for joining. And again, we will respect your time, and we will bring you another update very soon. Have a great afternoon, everyone.